why would that overwhelming number of the citizens having firearms not have a deterrent effect on tyranny that would still effectuate the individual right model as articulated by Professor Barnett and others?
Your deterrent effect on tyranny is the 90 million people standing strong. The fact that they have handguns facing the kind of weaponry. I mean, if you wanted to tell a terrible story about a military overthrow of this government, do you think that the military overthrow is going to be deterred by the fact that there's going to be 60,000 poor sons of bitches standing around with a handgun while they get mowed down by the kind of firepower that they could bring to bear on them? You can't seriously think that the Second Amendment is a real protection against overthrow by a horrible tyrant. What it is an important symbolism, and I don't denigrate the symbolism. But my sense is that if 90 million of us would stand against an overthrow by this government of this government, it isn't handguns that's going to protect us. It's the solidarity of a people that's going to protect us.
Thank you, Professor. From my cold dead hands.
I mean, Burt may be right about that, but it's a prudential matter that has to be made given unforeseeable circumstances about what kind of threats people face. And I think, I don't want to go through a whole critique of his analysis of the Second Amendment. I don't think individual rights people disregard the first part of the amendment. I think that was a straw man in the article. I think we have a theory that explains both parts, and I think we understand as well as the founders did that the militia, which is the militia of the whole, not a select militia. The militia serves a number of important purposes, and they can be summarized as personal and collective self-defense, or what state constitutions refer to as the defense of themselves and the state, or themselves and the society. So that individual self-defense is part of what an armed population allows, and also collective self-defense is part of what an armed population allows. The armed population is, another word for that is the militia. The government has the power under the Constitution to regulate it. There's no denying that. The fact that they choose not to regulate it is no indictment on the underlying requirement for there to be a general militia, and that is an individual right to keep and bear arms. So the failure of the government to well regulate the militia or to call it into effect, by the way, it still statutorily exists under U.S. code, is the government's fault. And they cannot undo a constitutional right because of their failure to use the militia the way they're allowed to if they want to.
Next question.
This is a non-Second Amendment question.
Oh, good.
Thank you.
Ilya Soman, George Mason Law School. I was interested in your theory of the 10th Amendment as essentially creating a rule of construction under which powers are construed narrowly and additional powers cannot be added by implication. And I was wondering if you could expand on the implications of that for Congress's powers under Article 1, because I'm sure you recognize as well as I do, especially since the 1930s, Congress's powers under Article 1 has been vastly expanded, their interpretation by the court almost entirely by implication. Certainly, if we just look at words like interstate commerce or general welfare and the like, you would really have to add a lot of implications and penumbra and the like to them to get virtually unlimited congressional power as we have today. So does your theory imply that that should be cut back, and if so, how far?
I argue, it's a good question, I argue in the piece that the Rube Goldberg causation notions that we've used for the Commerce Clause are probably in tension with the 10th Amendment, and that Justice Harlan in Wirtz, and Harlan thought more about the 9th and 10th Amendments, I think, than almost any other justice. Justice Harlan in Wirtz versus Maryland, in his separate opinion, urges us to rethink the notion that the Commerce Clause language is infinitely elastic, and he urges us to read it more narrowly, and I think he's right. I mean, in some sense, the 10th Amendment jurisprudence grew up because the construction of the Commerce Clause essentially got out of control. And you wouldn't need a rigorous 10th Amendment jurisprudence if you had a narrower and, I think, more sensible reading of the Commerce Clause itself.
Next question.
Yes, Brad Smith from private litigator from Michigan. One thing that troubles me, Professor Neuborne, about your holistic approach is that it implies that the answers are self-contained in the Constitution. And maybe that's an unfair implication, but for generations, judges construed or I should say interpreted the Constitution. Can you hear me? For generations, judges interpreted the Constitution in light of the Declaration of Independence and the Federalist Papers. Would your theory rely more or less or the same on documents created at the time, like the Declaration and the Federalist Papers?
Short answer, it would rely much less. Much less. And in fact, I think when judges claim to be reading the text against the background of the Declaration of Independence or the Federalist Society, what they're doing is simply creating a facade to explain why their reading is the reading they like is the reading that is going to be adopted.
If I could just a quick follow-up, moderator. Sure. I mean, that presumes that the drafting of the Constitution was done by a master, intelligent, cohesive thought, and all of the records that we have, and I'm not the scholar that the panel is, perhaps, but it was a contentious summer in Philadelphia, and a lot of people compromised, and there was a lot of debate. And so the idea that it's like the Bible, this is like handed down, does not fit with history.
Oh, I don't know. They didn't do a bad job. My sense, there's a cover of Nation magazine, 3-4 years old, but it is a hilarious cover, and it's the story of devolution, not evolution, and it shows the founders as these giants way back, and then at each generation, the next generation of political and intellectual figures becomes a little less. And at the current time, we're crawling into the slime in reverse order from the founders. And I think there's something to that. I don't apologize for clinging to that document and using it as the thing I steer by.
There's only time for one more question. Unfortunately, we have a deadline, so you may go ahead.
Thank you. I wanted to address the application of this to the Constitution of 1789. It seems to me we have an example of that in McCulloch versus Maryland, where John Marshall looks at the word necessary in the necessary and proper clause and reasons, given that we have the phrase absolutely necessary elsewhere in the Constitution, that necessary means something other than absolutely necessary. And is that an application that you would accept?
Well, I have to think a little bit about it. I mean, if you want to really see, I think, the best discussion in our history about that, when Washington called his first cabinet together, the cabinet would write opinions to him about important constitutional issues. Jefferson and Hamilton debate the meaning of the necessary and proper clause in the context of whether the government has power to create the first bank of the United States. And the exchange about the meaning of necessary and proper, I think, is just brilliant on both of them. But I don't know enough about it to hazard a guess on a particular issue.
Any last words from Professor Barnett?
I think that even McCulloch provides a good example of what I'm cautioning against. I think, by the way, juxtaposing absolutely necessary with necessary is useful and tells us something. I think it tells us it's consistent with Madison's reading of the necessary and proper clause as not meaning indispensably requisite, which is what was argued by Maryland. But what Marshall does is he takes the word necessary, he says it means convenient, and from then on we're off and running with the word convenient. And convenience actually had probably a slightly stronger connotation than it did after in the New Deal, by the New Deal period. But again, it's taking one word, substituting another word for it, and then taking that word, and that becomes the Constitution. That's what I'm cautioning against.
What a great start to the day. Please join me in thanking our speakers.